everyone, and welcome to this Federalist Society virtual event. My name is Edith Harold, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host this FedSec forum called Time for a Checkup, Evaluating the Withdrawal of Healthcare Antitrust Guidelines. Speaking on the panel today, we're joined by John Carroll, Richard Feinstein, Laurel Kilgore, Barry Nigro, and Professor Barak Richmond. Joining us as our moderator today is Adam Beagle, who is a partner at Alston & Bird and a co-chair of its Litigation and Trial Practice Group. If you'd like to learn more about today's moderator or speakers, their full bios can be viewed on our website, fedsoc.org. Throughout the program, we may turn to the audience for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers and not the Federalist Society. With that, Adam, thank you for joining us today, and I'll hand things over to you.
Great. Thank you very much, Edie, and welcome everyone. As Edie said, I'm Adam Beagle with Alston & Bird's Washington, D.C. office, and a member of the Federalist Society's Corporation Securities and Antitrust Practice Group Executive Board. So thank you for joining today's program. I'm going to give brief introductions of our panelists to begin, and then give it some introductory remarks before we begin our discussion, which I think should be stimulating and timely and important for those who are counselors and advisors and those interested in antitrust enforcement and antitrust policy. First, taking our panelists in alphabetical order, we have John Carroll, who is a partner in the Washington office of Sheppard Mullin, who practices in a wide variety of antitrust areas, including mergers and government investigations. And he is a former lawyer with the Federal Trade Commission's Bureau of Competition in the Mergers One shop, where he spent a significant amount of time on healthcare enforcement matters and investigations. Next, we have Rich Feinstein, partner with Boies, Schiller, also in Washington. He also participates in a variety of antitrust cases on both the plaintiffs' and defendants' side. And he has served multiple tours with the Federal Trade Commission. He began, as well as the Department of Justice. He worked as a trial attorney with the Antitrust Division in the Department of Justice. He also later served as Assistant Director of the Bureau of Competition at the FTC, in charge of the Healthcare Services and Products Division from 1998 to 2001. And he returned to the FTC during the Obama administration to serve as the director of the Bureau of Competition from 2009 to 2013. Next, we have Laurel Kilgore. Laurel is research manager at the American Economic Liberties Project, where she manages their team of policy analysts and coordinates with expert advisors and fellows to develop original research and policy briefs. She frequently speaks and writes on a variety of economic liberty topics, including competition. She is also a lawyer who has served in private practice and also worked in a variety of international organizations, including the Balanced Economy Project in Europe and the World Health Organization. Next, we have Barry Nigro. Barry is a partner in the Washington office of Fried Frank and global chair of their Antitrust and Competition Department. Previously, he served as the Principal Deputy Assistant Attorney General for Antitrust during the Trump administration in the Department of Justice, as well as the Federal Trade Commission's Deputy Director for the Bureau in the Bureau of Competition. We also have Professor Barak Richmond, who is the Alexander Hamilton Professor of Business Law at George Washington University Law School, where he counts antitrust among his research interests and has written about healthcare and antitrust, and also holds appointments in various shapes and forms with the Stanford University School of Medicine and the United States Department of Health and Human Services, and has been affiliated with the American Antitrust Institute. So we have a very well-credentialed panel with a diverse array of experiences in government and private sector. And with that, I wanted to begin our discussion. Over the past few decades, it has been unquestioned, both over Democratic and Republican administrations, that competition has been important to the American healthcare sector in our economy. It is frequently reported that healthcare expenditures account for more than 17% of the United States gross domestic product, thus making competition an important issue in that sector. But as we all know, while healthcare can have very much a kitchen table and pocketbook effect because we are all in some way, shape, or form every day consumers of healthcare services and products. It is also a unique sector in the American economy. It has very different payment structures. It has very different and large roles of government expenditures as a consumer and participant in the healthcare system. And there can be some significant costs to entry as well as particular government regulation. So with that in mind, when you look back over the arc of antitrust enforcement over the past few decades, the federal government has sought to give some guidance to participants in the healthcare sector. As early as 1993, there were published guidelines called Statements of Antitrust Enforcement in the Healthcare Industry that in 1993 were, quote, done to advise the healthcare community in a time of tremendous change and to address as completely as possible the problem of uncertainty concerning the antitrust agency's enforcement policy that some had said might deter mergers, joint ventures, or other activities that could lower healthcare costs. So those enforcement statements, or guidelines as they're often referred to, were amended in 1994, 1996, to the 9 that stood until very recently, covering a variety of business topics, including joint ventures, information exchanges, and other collaborations, providing safety zones and inviting requests for business review letters and other advisory letters from the antitrust agencies. And as we're going to discuss today, they've often been used by healthcare companies and even those outside the healthcare sector to govern their business activities so as not to run afoul of per se antitrust violations or to try to rightly balance the efficiencies and cost savings and quality improvements that the guidelines were intended and the antitrust laws were intended to promote. There also were a set of guidelines rolled out in 2011 about accountable care organizations in light of the Affordable Care Act that was also intended to help market participants properly gauge risk levels and govern themselves accordingly to comply with the antitrust laws. But that brings us up to February of 2023, when the Department of Justice withdrew those antitrust guidelines that had been in existence since 1993, and they did it in the name that I'm reading a Department of Justice press release to better promote competition and transparency. The same Justice Department that released those statements in 1993 then said that the healthcare landscape has changed significantly. As a result, the statements are overly permissive on certain subjects, such as information sharing, and no longer serve their intended purpose of providing encompassing guidance to the public on relevant healthcare competition issues in today's environment, leaving it to a case-by-case analysis. And then in July of 2023, the Federal Trade Commission issued a very similar statement to withdraw their sponsorship of the guidelines. So with that table setting, it brings us to today's discussion to cover a few topics. Well, primarily centered around what does this all mean? We have seen a variety of enforcement actions and statements since 2023 from the agencies, whether it involves pharmacy benefit managers, mergers, or a recent speech by the Assistant Attorney General saying that the healthcare industry has too much platformization that needs to be attacked to protect the American consumer and competition. And of course, with the upcoming change of administration, it does raise a variety of topics about how businesses should govern themselves and what you can do in the absence of guidelines. So with that table setting, I wanted to ask Rich. Rich, who was at the FTC and participated in some of the implementation of the 96 guidelines in the years after their enactment, can you talk to us a little bit about the guidelines themselves and what they were trying to do and what kind of activities they were trying to cover that I began to introduce. But could you dig into that in a little bit more detail so our attendees today can have an understanding of what we're talking about a little bit more?
Sure, I'd be happy to. One of the things that struck me, I went earlier today, I went back and took a quick look at the 1996 guidelines, the ones that have just, well, not, I shouldn't say recently, since it actually occurred a year and a half ago. But those were the ones that were withdrawn. And that document is, I hadn't had occasion to look at it recently. It is remarkably welcoming to the healthcare industry. back in the mid-90s, there was a lot going on in healthcare markets, but there wasn't the sense in requesting or in laying out this path forward, whereby there would be the guidelines and not 9 separate guidelines, and the welcome, or what at least struck me as a very welcoming tone in terms of the goals. I was even more struck by the tone of the more recent decisions by the antitrust agencies, which basically were that both the Antitrust Division and the FTC have explicitly found that much of the 1993 and 1996 policy statements are, quote, outdated and no longer reflect market realities in this important sector of the economy. That's the most significant statement, or I would say, regarding this, regarding the current state of play. But I'd even say the tone of that announcement was much more adversarial than the tone of the initial safety zones in 1996. And just to give a quick rundown on what those were, they were, as I said, there were 9 of them: mergers among hospitals, hospital joint ventures involving high technology or other expensive healthcare equipment, hospital joint ventures involving specialized clinical or other expensive healthcare services, providers' collective provision of non-fee related information to purchasers of healthcare services, providers' collective provision of fee-related information to purchasers of healthcare services, provider participation in exchanges of price and cost information, joint purchasing arrangements among healthcare providers, physician network joint ventures, and multi-provider networks. So it was back in 1996, it was a fairly exhaustive list of issues, there's quite a contrast between the description of the world for hospital joint ventures, for example, or other expensive healthcare equipment back in the mid-90s, compared to the general tone of the withdrawal. And what I also wanted to take note, that it's important, if guidelines are going to have any value, that they accurately reflect current enforcement policy and agency practice. And to the extent that guidelines fail to do that and are thereby out of step with enforcement policy, they're less useful. Here, both the Antitrust Division and the FTC have explicitly found that much of the 1993 and 1996 policy statements are outdated and no longer reflect market realities in this important sector of the economy, and on that basis have withdrawn those statements. That's to me, that's an important development as well. Because when you're preparing guidelines, which is something I've had some occasion to do, I worked directly on the 2010 merger guidelines. You really need to have you really need to have a level of confidence that they reflect enforcement realities. And it's on that basis that the agencies move forward. And the decision to rescind in last year what had been the existing guidelines was made very explicit the view that they weren't useful if they didn't reflect enforcement reality, and essentially concluded that they didn't sufficiently reflect enforcement reality, at least under the view of the current administration. So let me stop there and we'll move on.
I mean,
No,
you know, just to comment on Rich's last point, I think it's important to keep in mind that the guidelines are an expression of enforcement policy. So they don't make the law or change the law. They can be influential and a reference point for courts, and they're useful in providing practical guidance to the business community, hopefully translating some of the complicated legal issues that we deal with in our antitrust world into plain English. And so, you know, it's not a surprise after almost 30 years that the agencies would take a look at these guidelines and have some concerns that they did not accurately and precisely reflect sort of how they think about healthcare enforcement. Beyond that, I mean, I think all of us have had this experience where these healthcare guidelines are used in a lot of contexts that have nothing to do with healthcare. Some of the information sharing guidelines and joint venture guidelines and other things are you know, have over the years provided a good, useful, practical point of reference when thinking about those same issues in other industries. So, you know, they have influence beyond just healthcare, and you know, I think all of us have probably referred to them at one time or another in non-healthcare context.
Yeah, that makes sense. And just to pick up, I think on those two really good points Barry just made. I mean, if the while they're not law, guidelines are purported to reflect agency thinking. And as Rich said, if they don't reflect agency thinking, then maybe they're not that helpful. But I think the frustrating thing here is the 9 statements were what, Adam, 140, 150 pages long total?
pretty
So
thick.
there was a lot of guidance. So does that mean all 150 pages are no longer consistent with current agency thinking? Or could the agencies have maybe used more of a scalpel to say, okay, well, we no longer think about, you know, rural hospital mergers, right? Like if you look at the statement on rural hospital mergers, I forget which statement it is. That's pretty inconsistent with some of the enforcement actions the FTC has brought. Fair enough. So you withdraw that statement or you replace it. You know, to just summarily withdraw all 141 pages and not, you know, this was done, I think, as Adam said, back in early 23 by DOJ and then later by FTC, and to not replace them with anything or not update them, I think is what creates a challenge for those of us who advise, you know, healthcare systems, particularly providers on a daily basis, and just trying to, you know, what they would say is comply with the law. I don't know if we think about it as compliance, but these are healthcare folks. So they think about things in terms of compliance with federal law. And instead we get, you know, I think it's called the healthcare portal, which was announced back in April of this year, where businesses or individuals can submit a complaint about activity that may violate the antitrust laws. And there's a link in there that provides, you know, a list of 8 to 10 different things that could violate the antitrust laws, many of which I think facially may not violate the antitrust laws, but nevertheless, that guidance is fairly scant. So I think it's just, you know, on a daily basis of advising businesses who are really trying to do the right thing and are used to dealing with probably the most regulated industry in the United States, if not the world, and are used to dealing with CMS and all these different things coming down from the feds and the states. You know, they just want to do, like I said, do the right thing and not run afoul of the antitrust laws. And I think that's a source of frustration from a practical perspective.
No,
John, can you speak maybe to the?
Adam, I know we've already wrested control from you, so reimpose it.
That's
if you need
fine.
to. I'll just say very briefly, I like Richard read these within the last week, and I was shocked that not only they were still effectively not withdrawn until 2023, but that anybody would rely on them. It describes a healthcare marketplace that is 1980s technology and organization. Since all the statements, we've changed from Elzinga Hogarty to the two-step replacement process. We allowed lots of mergers on the understanding that integration would lead to efficiencies none have. We had allowances for the ACOs, thinking that they were going to be a signature feature in trying to reduce unnecessary care. They haven't. So they not only describe an old industry, but they describe old policy priorities that have all been abandoned because they haven't worked. So I'll even say that it's surprising to me. I mean, Barry, I believe you when you say this, but it's surprising to me that anyone would think that information sharing in a physician network space would be applicable to others where, first of all, there are no physician networks anymore. It was at the time of the last guidance, about 75% of all physicians were part of some kind of independent network. Now the number is closer to 20%. There are no physician networks anymore. To the degree that they share information, it's not sharing price information, it's sharing EHRs, which present its own very unique set of competition challenges. So now I take John's point that maybe it's not a good idea to take all this away and not put something in its place. But what should be in its place is something that's going to be really, really hard, given the enormous structural changes that have happened in the industry since 2010.
One of the things that, could I jump in just for another 30 seconds? One of the things that struck me when I revisited the 96 guidelines was the emphasis that was put on providing guidance through business review letters or advisory opinions. And they committed to getting them done quickly. And that, in principle would be helpful, but as I don't believe it in actuality, that has ever really happened. And I think it's gotten to the point where people don't request them anymore very, very frequently, at least. And in fact, one of the things that I don't know for sure, but I assume well, I shouldn't assume. I wonder whether business review letters or advisory opinions from the FTC are even available.
They are
on this topic.
They are. That's what doesn't make. We have completely taken over the panel, Adam. I'm sorry.
It's a good discussion.
That's what makes this also frustrating, right? And unusual is I disagree a fair amount with what Barack just said on physician networks, by the way. I think most physicians are in some form of physician network. I think statements 8 and 9 are very much still applicable, even though they were written in the 90s. I take your point on the technology and the impact of the Affordable Care Act, but the Affordable Care Act, if anything, accelerated, information exchanges, clinical integration, collaboration, things like value-based contracting that I think you can find, if not explicitly in statements 8 and 9, certainly in the thrust of 8 and 9 and the pro-competitive benefits of clinical integration. All that said, the advisory opinions and business review letters are still available, and in theory, seek to rely on the guidance. So I don't know if it was administrative error or what exactly occurred, but you can still look up, if you're trying to figure out whether a physician network would be considered substantially clinically integrated, you can still look at MedSouth. I mean, it's 22 years old, but you can still look at that advisory opinion, that letter, and in theory, it still purports to reflect, FTC staff thinking on clinical integration.
Are they still accepting requests for advisory opinions and I know they're old ones. I'm talking about they're still available.
I don't know. I mean, Frank, I don't know about you guys, but I've never thought it was a good idea to ask for one. I always advise just to look at the law, right? Understand what the risk is, take the risk or don't take the risk. So I have to admit, I've never actually asked FTC staff for an advisor opinion or DOJ staff for a BRL.
Yeah, I think to get one that's meaningful, you almost have to ask a question that to which the answer is clear. The agencies tend to take a conservative approach because they, they're committing their opinion to paper. And I know there's the caveat in there that you can't rely on it, but people do. And so, a lot of the things where you might have a shot at getting a business review letter or an advisory opinion are things that probably don't merit it.
Right. Totally agree.
Yeah, I guess, Laurel, let me bring Laurel into this too, because I think there's also, there was some discussion at the time they were withdrawn that the reliance of the guidelines outside of the healthcare industry did play a role in this too. That information exchange, like Statement 6, because it's been looked to so often, might be a hindrance to things like information exchange, like the real page matter involving real estate pricing and other things out there. So can we maybe take a step back? I don't know, Laurel, what's your take from, I guess, a policy perspective or legal perspective on how this fit in light of some of the things that Barack said and others said? Would you mind giving us, I guess, your policy perspective, since you live and breathe in this area too?
Yeah, so I would say that the withdrawal of the guidelines was motivated by both sort of, you can take a narrow look at it and a broader look at sort of the motivations for it. So in the narrow view, you can look at what the agencies said in their press releases about why they were withdrawing these statements. Both the FTC and the DOJ highlighted in particular their concerns about information sharing. So they were concerned that in the digital age, it is much easier to collude and coordinate in bad ways. Doha Meki, Principal Attorney General, gave a speech at GCR at the same time that DOJ withdrew the guidelines that gave a little bit more elaboration on the information sharing angle. So I would encourage people to read that speech to get a more in-depth understanding of their concerns about information sharing. So one of the things she brought up is that the information sharing guideline has a sort of a 3-month guardrail. She says that is outdated possibly in the age of machine learning. So historical data, something or aggregated data, much easier in the age of machine learning. It would be very hard for people in the 1990s looking manually at this to draw inferences based on things that, old data from, many months ago. Machine learning, you might be able to find ways of collusion based on that. So that was one particular aspect of it that she highlighted. She was also concerned about third-party intermediaries can be anti-competitive using intermediaries. And we've seen a rise of different startups. So as Adam mentioned earlier, concerns about startups like AgriStats that seem to incentivize collusion between actors in an industry and engaging in restraints of trade. And actually, if you look at the timeline of when these were withdrawn, so the DOJ withdrew in February, the FTC withdrew in July, and then the AgriStats case was filed in September. So they were likely working on that case, on that investigation, that probably influenced their thinking and concerns about information sharing. And as Barry said, people outside of the healthcare industry have decided to rely on the healthcare guidelines. So I think that motivation of seeing the rise of startups that facilitate collusion has been a concern. And we've also seen that with the DOJ's recent case against RealPage, which is alleged to do algorithmic price fixing among landlords. So that's also been a concern. So beyond information sharing, there were also some other things she mentioned, including concerns about industry roll-ups. So roll-ups in the healthcare industry is something that post-dates basically all of these guidelines in terms of research into roll-ups and just phenomenon of roll-ups became much more prevalent after these statements were put into place. Also in Jonathan Cantor's recent speech, there were a number of different characteristics of the healthcare industry he was concerned about. One that I will highlight is conflicts of interest, which can result in steering, self-preferencing, exclusivity. So that's something that the administration had been looking at quite deeply in the context of big tech, and noticing those similar patterns playing out in the healthcare industry, for example, with an insurer, PBM, self-preferencing its own pharmacy over other pharmacies, either by steering customers or by giving much more favorable reimbursement terms to its own pharmacies versus other independent pharmacies. So I think those were some of the specific concerns that influenced it. And then there are also sort of, the broader rethinking of antitrust enforcement that was going on in the Biden administration. So in July 2021, you had the executive order on competition, which instructed the agencies to enforce the antitrust laws more vigorously, instructed the agencies to revise the merger guidelines. So that revision of the merger guideline process, that was a 2-year process of a lot of different listening workshops, public comment sessions, 5,000 public comments. So that was going on in tandem. So you had the withdrawal of these statements in the healthcare industry in early 2023, basically the same month that the first draft of the merger guidelines that applies principles across all industries that came out in summer of 2023, at the same time the FTC withdrew in tandem, it withdrew the healthcare statement. So this is sort of like the holistic view. And I think the agency's view was that, the default is you go back to, healthcare not getting special exemptions or special treatment, but is going to have to apply the same general law, the same general principles as other industries.
I think, Laurel nailed it. I think that the motivation was likely, I don't know, but was likely substantially influenced by those pending investigations and their desire to bring enforcement actions. And the last thing they wanted was to have their own words cited back to them by the defendants. And there are a lot of words in 140 pages that are not necessarily helpful to the FTC or the DOJ. In addition to that, the FTC had just published a Section 5 policy statement that's really broad and covers a wide range of activity. And these guidelines, as Adam, as you said, and as they state in the very first page, were intended to sort of provide as completely as possible sort of more certainty and transparency. And so, you have an administration that some have said thrives on uncertainty. And they also have been clear that their approach to antitrust is to be law enforcement oriented, which means bringing cases and developing the law that way. Although when it comes to some things like non-compete rule, they want regulation. So I do agree completely with Laurel that there were probably some specific enforcement actions that motivated the desire to get these off the books.
So I guess let's open up the floor then for what does this mean? Because if you're a healthcare company, as John said, trying to comply with the law, do the right thing, promote all the interests that we might agree that motivate the antitrust laws across administrations, is this a sea change, a little changing of the tides for an hour or two? And if you want to do something good, should you sort of bite your tongue and wait and see? How do we put this in perspective? If you're, a healthcare company or trying to do good, should you rip up your policies? Should you not do joint ventures? What I don't know, Barack, I know you were going to help lead this discussion. What's your take? Is this an important moment in time or something that's smaller, tethered to a handful of cases?
I mean, so if I'm hearing what Barry's saying correctly, it's that they wanted to make sure that these documents were withdrawn so they could pursue information sharing cases in non-healthcare settings, which makes sense to me. But it kind of illustrates exactly the role that these documents have been playing over the last decade. The biggest influence is on cases like the case against RealPage. I mean, that might be the case precisely because it describes a health sector that's just not there anymore. Now, I think your question about certainty, about what people who are trying to do the right thing, what is next for them is an important one. And I hear John when he says that it's very frustrating that he doesn't know what to guide clients with. But if we're looking for perspective, it's the following. We have had an incomplete failure of antitrust policy in the healthcare space over the last 30 years. Things have gotten bigger and less efficient. Most of the transactions have been justified on the efficiencies that come from clinical integration, and there has been no clinical integration. There are diseconomies of scale. There might be some ability to trade information because of these mechanisms, but they certainly aren't the least disruptive way to do it. And in fact, they've foreclosed most markets. We've gotten this wrong from soup to nuts. Now, from a policy perspective, I would say I would like to think of an agency would dedicate its limited resources to trying to figure out how to get this right, rather than providing clarity on a wrong-headed policy. And in that sense, I think we all have to take a step back and try to figure out exactly what each of us can do to figure out how to make the markets a little bit more competitive. But business as usual is the road to disaster. You said it was 17% of the economy. It's actually closer to 19% of the economy.
Okay.
And we're the least healthy country among OECD nations. This is not the path to success.
So it's a sixth of GDP, but it's a half of antitrust enforcement, roughly, right? Since 2000. So I think in terms of Adam's question of, well, what do you do now? I mean, I go back to what Barry says, which is, well, the law hasn't changed, right? I mean, the law is the law. And on physician price fixing, you have Arizona versus Maricopa, right? Physicians were not commonly employed. They agree on price related terms. It's price fixing. And so, you got to go from there. You still have, you still do, notwithstanding our commentary on the age and applicability of the advisory opinions, you can still look at advisory opinions and say, well, look, I mean, we are, and I take Brock's point. I disagree with that one too. And there's no clinical integration. I think there is clinical integration, but I think you can still look at what your clients are doing and say, look, they're doing this, they're doing that, they're doing all the things that were blessed by these advisory opinions. They're achieving X, they're achieving Y, it's pro-competitive, it's defensible. Okay, so then these old guidelines were withdrawn. That doesn't mean the law is any different. And we do have some guidance from the agencies in helping our clients put together and multi-provider networks.
And I think the guidelines can still provide a starting point. The law hasn't changed, but when they were issued, they presumably reflected some version or interpretation of the law, and so they can, they can be a point of reference. Somebody asked in the Q&A, where in the hierarchy of constitutions, statutes, regulations, procedures, rules, private letter rulings, etc., the guidelines reside, and is a safe harbor really a safe harbor? I mean, I've always thought of guidelines as an expression of the agency's enforcement policy, which is intended to, provide transparency to the public as to when the agency will and will not bring a case. It's also a way to communicate with staff how the agency intends to exercise its discretion, prosecutorial discretion within the law. It also is the case that courts frequently look at them, especially if they go through a notice and comment type of process. And for that reason, you see courts often referencing the merger guidelines, and through that process, by incorporating them in decisions, they sort of become a part of the law, but they're not the law. The guidelines don't change the law. They don't define the law. They're simply an expression of enforcement policy.
Well, let me say quick, I think Barry's exactly right. And I think John's exactly right in the sense that he says that the law hasn't changed, but let's put it this way. Maricopa applies to very little of the current healthcare marketplace. What does apply much more so is the Microsoft case. Now, both of them are still good law. Both of them are embedded in the Sherman Act. But how you apply these principles to maximize or achieve competitive objectives are entirely different because we have a very different strategy. We have a very different marketplace, a different structure. So now it would be really interesting to think of how the FTC would apply the Microsoft principles to the healthcare space. That would be a very productive document, but thinking that we're in the world of Maricopa just isn't helpful.
Right. So from a practitioner perspective, I definitely agree, having come from a space where I was not in healthcare, but advising startups in a fintech space on things like money transmitter regulations. So, ask your fintech colleagues, how do they deal? They didn't have any kind of similar, 140-page guidance. You have to go and look case by case often at, state, and it's state by state. It's not federal often. So looking at advisory letters. So there are other areas of practice that haven't had this sort of luxury or benefit of just referring to these types of guidances for a very long time. So I don't think it's unique for an industry to be in that situation, as frustrating as it may be as a practitioner. But I do want to highlight from a policy perspective that, I think something is wrong with healthcare. And so, as I agree very much with what Barack has been saying. Just today, I came across a study that came out this month from Princeton, from an economist at Princeton, finding that insurance mergers account for 22% of overall cost increases in employer health plans in the past 2 decades. And doing the math on that, apparently a family of 4 in 2004, a typical insured family, paid about $4,000. With inflation, that would be $7,400 today. But instead, in 2023, they're paying $31,000. So that's $26,000 in additional costs of spending per year for a typical family. And that's, so that's if you take that 22% number, that's something like $5,500 per family that's due to insurance consolidation, according to this recent academic study. So something is wrong with the market, and whatever we've been doing has not been working.
Yeah, I mean, I think to your point on fintech, it's a really good one, and I do this stuff, it's particularly on the health system side and some payer side as well. Full disclosure, those are the clients that most of the clients I advise, and these are folks like, if you're in-house at a major nonprofit, for-profit health system or a large insurance company, your daily compliance life is looking at what the government has kind of told you is okay and not okay, right? What could be a false claim? What could be an appropriate billing and coding measure? What could be violative of HIPAA, right? And so you're used to getting some degree of certainty from an OIG opinion, from whatever it is, like to the question asked from I think it was a tax person. And so I think that context, and apologies if I said this before, I think that's the context for the frustration with this, notwithstanding, that certain parts of the guidance, well, come on, it was 1996, like whatever the DOJ person said, I think something along the lines of like, we were watching movies on VHS, like how could you ever think that watching a movie on VHS in that era would be applicable to today? Well, fair enough, but there's just this sort of daily practical, as you go around these all hands calls that I know you all have been on, like, okay, antitrust, I don't know. Like, there's nothing, there's the guidance is all gone. So this is the world in which we live. And that's the frustration. And it's a very practical one.
Yeah. So John, did you expect or want the agencies maybe to take some sort of examples of enforcement actions in the past year and a half, other than the information exchange ones that we talked about, maybe something in the healthcare sector about, someone that went too far in, clinical integration, financial integration, joint contracting, to say, well, at least don't do that, even if we don't have guidelines, because we're sort of falling back to like the collaboration guidelines, right? That haven't been withdrawn. You can still do good things with other people.
Yeah, I mean, I think more transparency and more communication from the agencies is a good thing. So, hopefully those aren't enforcement actions against any of our clients, but, if there are enforcement actions that spell out the agency's thinking, of course, that's a good thing to have. If there are speeches, I know Jonathan Cantor spoke, I think last week at Carnegie Mellon, and I watched that and it was helpful and interesting. But, and I keep going back to Barry's point on the reflection of agency thinking. I want to know what the agencies are thinking. The more I think that we all know, the better. and the more that we can advise clients, and the more efficiently the market works.
So then to try to, I guess, transition also as we think about what practically this means, I think we have to discuss then the change of administration. And as some of our audience members may have seen, you think even within the hour or two before this program, looks like we're going to have a new Attorney General nominee, let alone while we still wait for, perhaps, the head of the FTC and the head of the Antitrust Division. Let's maybe talk about what do we. I think we've discussed a lot of good things about what how guidance can and can't be effective, and what's going on in the healthcare sector, where guidance, as John was saying, is sort of the stock and trade of the healthcare sector. What do we think should happen or will happen after the change of administration in this space that we're talking about? Are we going to be just watching for enforcement actions? Are we could see a reinstitution of the guidelines for all we know, if everything was flipped, back on its, back on where it was? Or is it something in between? Or do we see, healthcare enforcement being something, very different from the future? So I'm sure each of you may have some different perspectives, thoughts, or suggestions.
Oh, go ahead.
Yeah. Barry, as the veteran of the first Trump administration, we'll let you kick that off.
Sure. I do not expect that these guidelines will be reinstated, and I'm not sure that they'll be, I doubt they'll be replaced quickly. And part of the reason for that is there's going to be a lot of other stuff to deal with. There are the new HSR rules, there are the new merger guidelines, there's the Section 5 policy statement, there's the non-compete rule. All of those are going to take priority over these guidelines. And putting together a 140-page policy statement takes a huge amount of work and a lot of effort to get consensus between the agencies. I worked on the 2020 vertical merger guidelines, and they were not that long, but they consumed a lot of resources, and there was a lot of back and forth with the FTC to try to get to a point where everybody was comfortable. And so I don't anticipate that this is going to be high on the list of things to do with the new administration, even if they think there's value in doing something. I also think we'll need to see what they do with the sort of algorithm cases and the agristats cases and those sorts of things, because how that law develops, and depending on what judgments are made as to how to handle those cases, could have implications for whether to reinstitute safety zones on information sharing, for example. So I don't have high hopes that these will be replaced anytime soon. I do think having guidelines in complex areas where the law is not so easy to sort out, and understanding at least where the agencies are is useful from a practical perspective, and that that's one of the responsibilities of the agencies, is to provide guidance for companies that do want to abide by the law, and not have to go spend $100,000 or $200,000 on a legal opinion every time they have a question. So I do think there's value, but I just don't see these being replaced anytime soon.
It's interesting. What Barry is saying, I think everybody's saying that all else being equal, guidance is very helpful. It's helpful so long as it is accurately reflects what the agency is going to do. And it's also very helpful if the agency is going to do something that actually is pursuant to enforcing the Sherman Act within the law. That's an ideal that I don't think we've had for a while, because these guys, because one reason the guidance did not reflect agency priorities, and number two, the guidance reflected an antiquated healthcare system. Now, there I guess are two things that could be done. I mean, I hear what Barry's saying. There could be some real effort to try to be very transparent about what the agency does or will do, that for sure would create value, would reduce administrative costs for members of the industry. It's just a good way to govern. But it doesn't solve the question of knowing what the right thing to do is given the current healthcare sector. Answering that question is going to be really, really hard. And it makes sense, the next administration's priorities is coming up with HSR, new HSR rules. I don't know when we're really going to start thinking about what the right competition policy is for the health sector. It will be really hard. It will be very hard for any one agency to do, let alone get consensus among agencies. But that seems to be the thing that we need to do. And I will make one slight distinction between doing something that creates administrative efficiencies, which is the language that Barry used, and doing something that makes the market efficient, which is what John said. Transparency from agencies might create certain administrative efficiencies, but it does not make the market efficient.
Fair enough.
So do we need a healthcare antitrust modernization commission to tackle the policy issues that then tries to, because I take your point that, the guidelines have to be motivated by some policy priorities and economic realities.
Well, the states are doing it. I mean, right? The laboratories, right? Look at California. California's revolutionized. California has revolutionized healthcare antitrust enforcement, or is trying to.
Oh yeah.
We may disagree on whether that's a good or a bad revolution, but it's since April 1st this year, look at that regime.
Well, but then also so has Louisiana, which is trying to use a COPA to preempt HSR. We're seeing
it's completely different. OCA is completely different, right? Like the OCA system in California is whatever you think of it is a significant change in, I keep saying a sixth. I think California is the 6th largest economy in the world, right? Or the 5th. So it's analogous to the size of healthcare relative to the rest of industry in the US. So they've completely redone their healthcare antitrust enforcement.
I mean, we are seeing, I guess you could call it experimentation in the states. We see transparency efforts in Massachusetts and New Hampshire.
Oregon.
We see, and in Oregon, we see other kinds of managed acquisitions in Louisiana and Kentucky and Virginia. I'm not sure we're going to get clarity from these experimentations, which is why I think, Adam, I liked your original idea of trying to come up with a modernization commission. But it will be interesting to see what the states are doing. I mean, I don't think we're going to get many nationalized lessons from what they do, but we might. I mean, and part of the reason, of course, is that the political economy of states are much harder to maneuver a good competition policy in. I mean, I'll just leave it at that. It's very hard to have well-informed, evidence-driven policy in healthcare in states.
The other thing I would add is that there is bipartisan momentum in Congress in some areas. So around PBM reform, for example, there may be things that happen during lame duck session, even before the new administration takes over. And that would also, that sort of consensus might impact what happens with healthcare guidance in the next administration. But I generally agree with the direction of what Barry has been saying, that I don't think that these guidances will be replaced anytime soon. And when, if they are replaced at some point, they will look different in some way than what the original statements were.
Okay. At the very least, might we get maybe an early, mid 2025 speech, at least, on healthcare enforcement, because there is a great tradition, whether it's Tim Muris or Jonathan Cantor, talking specifically to such an important sector that maybe could be a deliberate nod to my priorities are, whether it's continued enforcement of hospital mergers or vertical integration or, information exchange writ large. I imagine that could, with, I guess, less effort than 140 pages buried, could be, a nice thing if we were writing the, like the ABA does a transition report to the next administration, like that could be good, short of formal full guidance, at least a priority speech.
I think there's little question that you'll get one or more speeches early on, as John pointed out. Healthcare enforcement accounts for a disproportionate share of enforcement resources relative to its share in the economy. So I would expect that. I also think you could get statements of interest or amicus briefs filed in cases as well, which would reflect how the agencies are thinking about certain issues. I mean, that's a program that has, been used much more vigorously by starting with Macon in the last administration and continued with Jonathan Cantor in this administration. So there are lots of vehicles for expressing enforcement policy. Guidelines are not the only one. And sometimes, a speech or a statement of interest or amicus is a better vehicle because it's something that you're articulating in a more narrow way than trying to, publish guidelines where you have to think about every possible permutation and come up with a one size fits all, which can be difficult.
Terrific. As we're starting to near I think the top of the hour in this, I'll just invite our panelists to maybe offer any additional concluding statements, predictions, thoughts, desires in this space. And I think Barry, it sounds like you gave your closing argument there for predictions. Any other panelists have any requests, suggestions, predictions about what we might see or should see in coming years in healthcare antitrust enforcement and guidance?
To build on John's point, I will reemphasize the role of the states. And so in addition to states as laboratories of democracy, we also have states as antitrust enforcers. So and this is across industries. So where states are co-plaintiffs with the Department of Justice or the FTC, if the federal level takes a different approach, states may diverge and continue on in a more aggressive posture than the federal government.
We could have a whole other show on that.
Exactly. But we might.
I'll say very briefly, I would love, we do need leadership from government. It's going to be hard to get, and it may not happen in the next 4 years. We have some very significant thinking to do. And I would also love to get some leadership from the industry as well. I hear the industry has a compliance mentality. I hear that, I get that. But maybe having the industry really thinking about how it might chart itself with efficiencies and competition in mind would be very helpful also.
Well taken. Anything else to respect any of our other panelists? With that, I do want to thank all the panelists for a stimulating discussion. Hopefully we gave some of the attendees some additional things to talk about, some additional perspectives, and maybe pointed to a couple of things that they might see in coming months, coming years, and certainly some things to think about. So with that, I will thank them and thank you all for attending and turn it back over to Edie for any concluding remarks.
Yeah, just on behalf of the Federalist Society, thank you so much to our 5 speakers today and to you, Adam, for moderating. We're very grateful for your time and expertise. Thank you also to our audience for joining us. We really appreciate your participation. You can stay up to date with announcements and upcoming webinars on our website, fedsoc.org, or on all major social media platforms. Thanks once more for tuning in, and we are adjourned.